Can everyone hear me? It's a small room. I was hoping not to use the mic. But on behalf of everyone on the panel, we're absolutely excited and humbled to be a part of this process. And unlike Mr. Kramer, who came up here and gave us an elaborate and well thought out hypothetical situation, we are coming at the exact opposite end of the spectrum. We are coming with a practical, behind the scenes look of how cases are litigated in the United States from cradle to grave, how they're originated, how they're settled, the communication that goes on by and between counsel and class members, vis-a-vis the administrator, at every individual timeline point across the litigation continuum.
All in 15 minutes.
All in 15 minutes. Just by way of background, I'm Steve Weisbrot, and that's my business partner, Chris Chimicles, and we own a class action notice and claims administration company. My particular expertise within the company is communicating with class members in a way that is defensible to courts, that we can quantify in terms of a reach percentage, how many people we spoke to, what we spoke to them about, how the message was communicated, such that the court feels comfortable binding class members, absent class members, knowing that they had the opportunity to be heard, to opt out, to object, to become a member of the class. Mr. Chimicles, in addition to running the business end of the firm, has a particular expertise in distribution of class member funds and the best and most efficient ways to find people to give them their money. Melissa Wolchansky and Jim Shah are esteemed litigators in the United States doing consumer cases, doing antitrust cases, doing securities cases, and they're going to give you a peek behind the curtain as to how these cases are litigated from a very practical matter, including how these cases start. Where do these cases come from? Do they materialize from the thin air? Are there marketing? Is there marketing that's undertaken? And I'll kick it off to Jim and Melissa to just talk about where cases come from, how we start, etc.
Well, we don't have microphones, but we are litigators, so hopefully we can project. If you can't hear us, please let us know. So thank you, Steve, for the introduction. And just to start off, as you all have heard, we have private class actions in the United States, and many defense lawyers, it's their favorite question, where do these cases come from? Do you make them up? Do you sit in your office and you can, concoct them and then you go out and find clients, right? No. So the truth is, consumers contact our offices every single day, and often with problems that we unfortunately can't help them with because of the rigorous factors in Rule 23, but many times you will find consumers who contact us and they have problems that consumers across the country face. So in response to Steve's question, how do we get these cases? Many times the cases come to us. We also, you see a lot of regulatory actions. Do I need a microphone?
No.
Okay. Can everybody hear me? Okay. You'll see regulatory actions. An agency will send a threatened a demand, or you'll see the FTC, which is a regulatory body, will yell at a company for something that they're doing. Well, guess what? Oftentimes if there is any recourse from a governmental regulatory level, it doesn't compensate consumers. So you'll see often follow-on actions in the class context. We also work with a lot of nonprofit groups around the country who, I do a lot of food litigation and consumer product litigation. So you'll see consumer advocates who have consumers who come to them, and they will in turn come to us, and we will initiate a class action. So how do we find class representatives? Well, sometimes they come to our office, and sometimes we find them, because often you don't know that you are a victim until you find out that you're a victim. So you don't know, you see a lot of fee cases, you see a lot of consumer product cases. Often you don't know, one, what a class action is, or if you have a small dollar damage that you can actually find recourse in the courts, because who is going to hire an attorney to recover $100, $50, $5? That doesn't mean it's not a gross injustice and that the company isn't being, enriched by their fraud. So we will find consumers through website marketing, advertising. We do Google AdWords. We have Facebook pages, LinkedIn, and we will often advertise within the confines of the ethical rules what it is that we are investigating. And you will see class members will come to us. Often, if we have one case in one jurisdiction with one class member that is on file, I'll get 50 calls the next week on the same exact case because the consumers just didn't know. So referrals, these cases are all created either by consumers who come to us with something similar, other attorneys who notice something in a case that they have that is related, maybe in an injury case, and then they happen to be looking at some of their clients' contracts for a home that they're refinancing. I mean, consumers have, if you represent consumers in any fashion, my firm also does employment litigation. Oftentimes we find a consumer case that's kind of a tag along to an employment case.
Yeah, and I think that's right. And it speaks at some level to the conversation that I think Eric and Professor Miller are having in terms of private ordering. What we see a lot is that we'll have solo practitioners who might do personal injury work, might do employment work, consumer fraud work, and they have an intake with a client, and in the course of determining whether or not it's a case they would handle, they learn that this is something that is a prevalent problem either within a company or a product line, and then they don't necessarily have the experience or resources to handle a class action. So they'll call a firm like mine or Melissa's and say, hey, someone was in my office today and they're having this issue with their vehicle. I did a quick search online. It looks like there are other complaints about this. And so then they'll turn it over to someone who has more experience. So a lot of cases that we have been able to litigate over the years come from smaller shops like that. The other thing, and this goes to what Professor Coffey was speaking about, for example, I represented someone, a BMW owner, who was having trouble with the tires. The tires were needing to be replaced every 3,000 miles, and it was a prevalent problem. And we resolved the litigation on a nationwide basis, a good settlement. Got a call about 6 years later. I have a Volvo. It has a transmission defect, and under the new bill, we would not be able to represent that individual in the second piece of litigation. So, but I think that a lot of what we see comes in through people that understand they have a client or potential client that needs a remedy. They don't necessarily have the skill set or wherewithal for that particular type of case, and then they turn it over to firms that practice in this area.
So Jim, and Melissa, after you have the client and you're getting into litigation, what are sort of the biggest management problems as they relate perhaps to documents or class member information that you see, and how do you deal with those issues?
Yeah, and I think the thing that is, it's very taxing in terms of the hurdles that we face as class action practitioners in the U.S. right now, just to get a court to tell us that this can proceed as a class action. And Marco was referring it to in the Italian system as a motion of admissibility. Well, in the United States, it's a motion for certification that we're required to make. Unfortunately, you don't just file the case and then say, based on the allegations, we believe that there should be certification. In a typical case, be it securities, antitrust, consumer, first you're going to go through motion practice on just the pleading itself. If you survive that, then you're going to go through, generally speaking, extensive discovery. Often millions, if not tens of millions of documents, which requires significant electronically stored data, knowledge, and expertise, a lot of time and money. In this day and age, in almost every case, you're required to, at a minimum, have experts on the liability side and on the damages side. And in antitrust cases that, for example, Eric's firm specializes in, it can often cost $4 or $5 million just to have the damage, just to have the expert reports before you even know whether or not the court is going to permit the case to proceed as a class action. So when we talk about having leadership structures with, again, Volkswagen is a little bit of an anomaly with 24 firms, but still, it's not uncommon to have a leadership structure with 3 or 4 larger firms. And the reason for that is because it's going to cost millions of dollars just to determine whether or not you can proceed as a class action. So and in addition, there is, if you are successful in getting a case certified, and you're in federal court, the defendant has an automatic right to seek an appeal of that decision. Now, the circuit may not always take it, but Professor Coffey, I think under the new
Absolutely.
Right.
That's a 1 year delay in most circuits.
Exactly, at least, right? So then right now, the defendant can say, okay, we believe the certification was inappropriate, and most often the circuit will decline to take that. I don't know exactly what the percentage is. It's probably 10%
The
or.
circuit is different, but it's never more than 20%.
I think that's
going up.
exactly. But now it would be fast tracked. So even if you spent the millions of dollars, got a case certified, you would be put on hold for, depending on the circuit, anywhere between a year and 2 years. So that speaks to the time, right? Even in a well-managed complex case, you're likely not to get a certification decision for 18 months, sometimes a lot more. So I know that my firm, Leaf Cabraser, we finally resolved a line of cases for defective washing machines that we first fought, and those just were resolved in the past 6 months with distribution going to the class members, that we filed first in 2007. The went up to the Seventh Circuit and back, and up to the Seventh Circuit again. There was a petition for certiorari with the Supreme Court. So it's a long way of saying that it's hard to get a remedy for people. It takes a lot of time, a lot of skill, a lot of effort, and a lot of collaboration with people that are willing to fight the fight. There's a lot of barriers, but I think fortunately there are a lot of people in the United States and a lot of firms that are willing to take that risk, very substantial risk, and hold companies to account when they are not acting as they should.
Well, and for every case that we do take that might resolve in a year or two, you have the washing machine case, and we take all of these cases on a contingency. So our clients front zero costs, and if we are unsuccessful, they pay zero. So I have a similar case where my firm is lead counsel. It's a shingles case that has been up and down in Illinois to the Seventh Circuit, the IKO shingles litigation. It is 8 years old, and guess what? We can say it's been costing the firm a lot of money because it's millions of dollars in experts and litigation costs. What about all of the people who have defective roofs? I mean, the shingles are falling off of these consumers' homes, and we are just waiting for something to happen. It has gone up and down to the appellate court. We won, and we still can't get the court to issue a class certification decision. So the amount of time that is invested, which is why we collaborate. So for all of the defense lawyers in the states who say, well, you're just doing this in order to make, money in attorney's fees. Well, for every case that we might resolve that we make back what we put in, we are in the hole in many others. So that case is a depreciating asset, like many.
So the next point on the litigation timeline is also another pain point in terms of spending money for plaintiff's counsel, is if you are lucky enough after you've gone through this entire process to get certified, you now have to notify the class of certification. So you come in and you hire a firm like mine.
We call you.
Right. And we go through a process that lets the class members know that this case has been certified. This can cost anywhere, depending on the size of the class, from several $100,000 to several $1 million, with still no promise of settlement, no trial date really on the marker, and it's just another example of how much goes into the front end of these cases and why taking them on contingency and why laying out costs as a plaintiff's attorney is rewarded if and when at the end of the day you do get that settlement. And I think it's one of the equitable. It tilts the scales in favor of the argument for privatization, but it is an incredibly expensive endeavor. But the reason it's so important, right, the certification notice process, and the reason the courts are taking such a harder look at how that's done, the methods of media through which it's done, how many people saw it, is because you are potentially either at certification or settlement binding absent class members to a decision of the court where they may, if they don't know that they have the right to opt out, they are now subject to that case and the jurisdiction of that case, and it's very serious. A lot of people talk about notification in terms of claims rates and how do we get more people to file claims, where really sort of the jurisprudence behind the due process analysis of why notice is important isn't encouraging people to make claims. It's encouraging people to make an informed decision based on the information that's presented to them. And that's something that often gets lost in American jurisprudence. And there's all of these arguments that you're seeing more and more that an attorney's fee should be linked to how many people make a claim, or a notice process should be evaluated in terms of how many people make a claim. That is not sort of the paradigm or the background behind due process notice in the United States of America. It's letting people know that this happened. If you don't choose to act, you're going to be bound by it, and that's how it should be evaluated. But that was a very long-winded way of saying it costs a lot of money to do that.
And on the notice, if you guys could just talk a little bit about, 20 years ago, before social media, when there was notice, did it more in the traditional sense and publication and, LA Times and the like. Just talk about the evolution
Absolutely.
that you guys have seen in your industry.
Yeah. Well, and Steve, you should talk about what's going on in the Rules Committee in Washington right now as well.
So right now there is a proposed amendment to change the rule governing notice to include notice by, quote, electronic or other means, which is a real paradigm shift in the way that we're effectuating notice. Now I testified before the Rules Committee on this particular point a couple of weeks ago, and I've been working with the Federal Judicial Center to help craft best practices on how you use electronic or other means. And there's advantages and there's disadvantages. But the primary advantage to being able to use electronic means, as opposed to taking out a large ad in a consumer magazine like Parade, is frankly no one reads that anymore, and you're getting fairly abysmal claims rates as a result. When you're using electronic means, social media, Facebook, digital media, you can watch the results in real time, change your messaging based on what's working or what's not. We have a case where we are able to see which ads are resonating with people. If one is working more, creating more clicks to the website, whether they're filing claims or not, but they're showing interest, we start running that size ad with that particular graphic. We know that one works better. This may be a little bit too into the weeds of this, but we're doing something now on a Fair Credit Reporting Act case that no other claims administrator has done. Instead of using just emails for email's sake, we've emailed the people and told them they have a claim. We've then converted that email list into what's called a custom Facebook audience, which allows us to run Facebook ads to the specific people who are class members. So this is not a publication campaign done in lieu of individual notice. This is actually individual direct notice at a repeated frequency to class members on Facebook. And it's really very interesting because class members have the ability, it's actually for Eric's firm, but it's the class members have the ability to comment on the Facebook post. And there was, in some cases, a healthy deal of skepticism. They said, is this real? Is this a phishing attempt? Are people trying to get my money? And we would actively moderate it, and we would provide court links, and we'd say, here's the actual documents, go take a look at them. And then other class members started doing their own research, and they're commenting, and there becomes this sort of hive mind. But the bottom line is people are talking about the settlement. They're discussing whether or not to opt in. It's doing exactly what it's designed to do. And this could not happen using a medium like print or even television, because there's no interactivity. There's no ability to answer questions. So the ability to use digital media, I don't feel has been, even by the courts that are now considering in the United States, fully realized its potential. And we're really at a genesis of something very special in the notification world, because notification is really just advertising. And no longer are advertisers walking into their Madison Avenue advertising agencies and saying, I want to buy a quarter-page ad in the back of People magazine, and I want this particular reach percentage. They're using different words. They're using conversions. They're using key performance indicators. And we've been stuck in such a rut in the notification world, and primarily, frankly, because it's very easy for a judge to evaluate a print media plan because it comes with a neat little metric called a reach percentage. And the FJC has said there's a certain reach percentage that cuts mustard, and there's a certain reach percentage that doesn't, and it's very easy for the judges. Unfortunately for guys like me who are out there constantly advocating for more digital, more social, there's a huge educational curve for a largely older judiciary who doesn't, I testified in one particular case, we had 121 million internet impressions, and the judge, who's a very prominent judge in the United States, I won't name any names, said, Mr. Weisbrot, that sounds amazing. Now, tell me, what exactly is an internet impression? And I was just like, wow. So, long story short, notice is changing. It's getting better. It's getting more frequent. It's getting cheaper. It's getting more personalized. And we're really hopeful for us that, and for the for the community at large, that the proposed amendments to Federal Rule of Civil Procedure 23 are approved as they've been submitted.
And one of the things that I think I see as a practitioner is the benefit of being able to provide notice kind of in the new world with the social media. And when I spoke with potential plaintiffs, say 15 years ago or even 10 years ago, and I said, are you familiar with what a class action is? The answer was almost always no. And I can tell you that in the past 4 or 5 years, the answer is now almost always yes. So the provision of information about what firms that are trying to provide collective redress are doing and the benefits of that, I think, are being disseminated in a much more effective way. And I think it speaks to kind of a larger theme that was touched on yesterday, and that is, people, when they call us with an issue and we say, you know what, sorry, we can't help you because there's an arbitration clause and you're not permitted to file in court, you're not permitted to pursue this as a class action, they're really ticked off, understandably so. But we have to date have lost the battle in the United States in terms of how our business is portrayed. The Chamber of Commerce has won that battle to date in terms of portraying us as greedy and hurting companies. That's the narrative that gets out there. It's not the narrative of all the billions of dollars that have been recovered, all of the change in corporate policy, and so we constantly, all of us, have to work to try to change the narrative. And situations, for example, like with Wells Fargo, where fake accounts were created, accounts that customers didn't even know about, and then Wells Fargo's trying to insist that because they had arbitration agreements with those customers that pertain to their real accounts, that they couldn't arbitrate the disputes about the fake accounts about which they had no knowledge, right?
Because we're in Israel, we have to say that is the definition of chutzpah, right?
Okay, I mean, exactly. So there are things that are getting out there, but when people actually know what is happening, if they're giving up their right to file a lawsuit, General Mills, I think it was about 18 months ago, did something in the States where if you like them on Facebook, then they said that they had an arbitration class action waiver that was linked to that.
I think it was like if you even accessed the website.
Yeah.
It
Right.
was crazy.
So, and that became public knowledge, and there was a huge outcry. And General Mills reversed that policy. I think it was within 24 hours. All right, so people want to preserve their rights. They just don't know that they're not being preserved. So we need to do a better job of making sure they know what's at stake.
So in the settlement context, there are many, many things that as the class practitioner we do first is hire Steve and Chris, who are the experts in this, to make sure that we get notice out to the class members in the best way possible. But we can't just turn it over as, for due process concerns and as fiduciaries to the class. As class counsel, we stay very, very, very involved in the notice process. what the content of the notice looks like, where it is run, and it's important as the class practitioner to not just turn it over, because when we go to the court, we have to argue in favor of the settlement. But there are many things that we do in structuring settlements to ensure that, for one, the class members are in fact notified, and two, that we get as many people as possible to make claims in the settlement. So what does that mean? Like Steve said, redirecting notice and trying to find as many people as we can, getting creative with direct notice. I have a case right now, a consumer product, a defective product that is down the stream of commerce. So we went to the company and said, well, you know who your distributors are. Well, let's go to the distributors. How can we get lists from the distributors of who they sold the product to? And of course, the company did not want to do that because they don't want to implicate any of their distributors. But we insisted that they give us the lists of the consumers who they know, who they have, so that we can get direct notice to them.
I will say, just as an aside, Professor Coffey mentioned Judge Rakoff. Judge Rakoff, to my mind, was the first judge who actually ordered, as part of a notification campaign in a consumer case, that all of the distributors and retailers had to post posters in their locations alerting them of a particular, we did an olive oil case where we were in front of him, that they had been selling mislabeled olive oil, and it has now sort of become a model where...
From Italy.
Yeah.
It wasn't.
But no, that's a really good point, because so many of the consumer cases are so far downstream that if you're able to get direct notice information as opposed to relying solely on publication, you're going to be able to effectuate a more proper notice, a better notice.
Well, the issue is the company often doesn't want to give you that information. Sure. It's in their control. I have a case actually with Dan and Caleb against Santa Fe for natural American spirit tobacco, and we know that tobacco keeps unbelievable records of all of its consumers, and so you can bet when we survive the motion to dismiss in that case, which we know, that we will be seeking that information, and we will, look to get direct notice out to those people.
So, what's the last? So we've gone through notice. Now we've gone through notice of settlement. The last point is, how do we actually get the money into consumers' hands? And if we do get it into consumers' hands, how do we be sure that they're not just going to let this check sit on their kitchen table for the next 3 months and then go stale, and they don't deposit their check? And Chris, you have particular expertise in distribution. Can you talk a little bit about some of the ways that's been modernized?
Yeah, even in the last year, consumer class action cases, the way money is being distributed has changed dramatically. I mean, typically in the past it had always been a traditional bank check. Now we're using methodologies like PayPal. We're using digital checks, which are electronic checks that are actually emailed to an individual. They can click on it a few times and it gets deposited right in their account, or they can even print it out and take it to a bank and deposit it in that manner and fashion. And also checks. And to a practical example, a large case, and the washer cases were mentioned earlier, we're doing a case with Nick's firm, Leaf Cabraser, in the Whirlpool front-loading washer case, where about 400,000 people filed a claim, and I think 125,000 people chose PayPal, 125,000 people approximately chose the digital check, and about 150,000 chose a traditional bank check. So during the claims process, of which probably about 90% of those claims were filed online, a class member was given the choice of how they wanted to receive their funds, and they were able to choose that breakdown. So we're actually getting ready to distribute that money in the next couple weeks in that case. But as a practical matter, we're seeing these different distribution methodologies take shape and form.
Right. The other real interesting thing as a practical matter is using something like PayPal is very different than using something like a digital check, because a digital check still requires further action on behalf of the recipient.
Right.
To receive the email, to open the email, to click on the email, to enter their account number. If you've opted in for a PayPal account, we are literally putting the money in your bank account. And you don't have a problem with uncashed checks, unredeemed checks. That money, once it goes out, that's in someone's account, whether they want it or not. And it's being used a lot more because it's cheaper in these small value cases. We're dealing with a situation now where we have to send out roughly 22 million individual checks worth $1 or less. Well, that's typically more than the piece of paper it's printed on costs. But because of the way that the settlement was structured, that's what needs to be done. Allowing us to use a digital methodology gets it done, and using something like PayPal, no one's going to cash a check for $1. We're just going to send them and they're going to sit there. But if I have your PayPal information and I put it directly into your account, you've taken a settlement that was subject to severe criticism and made it a virtual certainty that it went into someone's account, which gives a lot more credibility to the settlement and a lot more likelihood of final approval.
Which is still $22 million, even though it's $1
Exactly.
to each consumer. So, I mean, that's where the class action device is so important.
And we're cognizant of the fact that everyone wants to get home for Shabbat and that we've ran a little over. So thank you very much. It was our pleasure to be here. We will take any questions if there are any, obviously. Yeah, please, sure. Sorry.
Because you mentioned Facebook, social media, do you like create a Facebook group or a Facebook site for a specific class, or how do you?
So it depends on the settlement. But typically we'll have an individual case website dedicated to a settlement, and then we will run advertisements that drive people to that site, because that site will have frequently asked questions. It will have all of the court documents posted. It will have a summary notice in plain English. So we have had situations where we built out a separate Facebook page, but it's really recreating the wheels, since we already have a settlement website, and we just redirect people once they click on the link on Facebook to the settlement website, and also they can typically file a claim on the settlement website.
Or Steve, for example, if you have a settlement, I just had a settlement in a case against Johnson & Johnson. They were selling their bedtime baby products and making misrepresentations, right? So in terms of what the administrator would do in that situation is it would look demographically at who was purchasing it, and then can determine what type of websites that purchaser would frequent, and then run banner ads about the settlement on the websites.
On Facebook also.
Right, that are geared towards.
Those are a little different, right?
members,
So there's two
yeah.
different technologies we're talking about.
Yeah.
And this may be too in the weeds for you, but that's programmatic internet buying, okay? And that's a demand-side platform where you create a demographic profile of who you're looking to reach, and you buy based against that profile. As opposed to Facebook, where you're literally you're targeting search terms, keywords, etc., and it exists only within the walls of Facebook. That exists outside of the walls of Facebook, and you could be on Time.com or NewYorkTimes.com and see ads if it's the type of website, or you're the type of user and you've been identified
That's
by
like
your
when you've
device.
looked for a pair, you've shopped for something online, and then you're on Facebook, and all of a sudden you see those shoes reappear 17 times.
Right.
Because you use
By way of
search terms.
example.
By way of example. But the same thing, if you're searching online for natural products or
But if you want to talk more about targeting,
I buy shoes.
you know, I could clearly do that all day,
Two
but I
in
don't
the
want to
mall
bore
yesterday.
everyone else with it.
When can I choose, if I'm in the class, can I choose which way I want to receive the money? So,
When you're filing your claim, after your claim has been accepted as properly filed, we typically have a drop-down menu that says, how would you like to receive your payment? In the event there is final approval, there's all this language you have to caveat, and then they can choose which way they want to do it, and we record it internally, and when we get to that point, we know how to distribute it to each individual class member. Sure. Thank you again.
Thank you.